well-known face, not only in the academics, but even otherwise. And the topic, since he specializes in the constitutional aspects, the topic today would be interpreting the legal materials in a purposive manner. We all know that there are different aids of interpreting. One is the internal aid and the external aid for statutes interpretation. So interpretation itself has a different facets as such. And once you have a person who is not only erudite speaker, but coupled with the fact that the way he puts the thing across, that's what I've never had the occasion to hear it, but that's what his students have always told me, that it's always a pleasure the way he connects the students. And connecting the students while teaching is the best aspect with which one can be associated with. And since I said that he has done a lot of webinars, seminars, and writing aspects, therefore we took, according to us, a very niche area of how to interpret the legal materials. And I'm a strong believer that if we understand that purpose, then not only the students, but lawyers and the different faculties would actually be enriched in the manner in which we put across. Without taking much time, I would request Professor SIDHARTH CHAUHAN, and product of St. John's, a famous school out here in Chandigarh, to take things forward, and it will be a pleasure hearing him.
Thank you, Mr. Vikas Chhatrath, for this opportunity. In fact, I started following your channel only recently, and I saw that many well-known judges, advocates, and law professors have already spoken as part of your series. And I think you're doing a great service for young lawyers and students by creating all this content on a regular basis and putting all your content together on a YouTube channel. So obviously, with online education, many newer possibilities have opened up. And I think you are doing a great service for younger law students and lawyers by putting all this content in the same place. So before I start, I have a Word file which I've created so that all the participants can easily follow what I'm saying, because my past experience with online seminars has been that if you don't use a textual background or a visual aid, it becomes very difficult for people to follow the discussion. So I have, in a way, typed out what I'm going to say so that it's easy for you to also read the screen alongside. I'll share the screen in a minute. But I just wanted to say one or two things about why I narrowed down on this topic after consulting with Mr. Vikas. So I'm generally teaching courses in Indian constitutional law, which are taught in our law school in the third year of the 5-year program. We have two courses, one on fundamental rights, the second one on structures of government. But amongst the optional papers, I get an opportunity to teach courses on interpretation of statutes and political theory. And of course, with every passing year, we have some flexibility to modify our courses and to update them from time to time. So I thought that since the forum that has been set up as Beyond Law CLC is supposed to be a repository of knowledge, which can be used by people even later on, I thought I'll begin with the introductory session today on approaches to legal interpretation, because I know that for many experienced law teachers and advocates, this might be material which they studied long ago when they were undergraduate students. But I think it always helps sometimes to go back to the basics and to present the basics in a structured way so that we can make it more useful for a larger audience. And I can see that amongst the guests who have joined us, some of them are already serving law teachers, some are advocates, some are students, and I'm sure many others will engage with us as this content goes online. So I've pitched the content at a very introductory level, but there are several ideas which I want to work through. So please bear with me if I speak a little fast. I have that, for that very reason, I have created a Word file so that it becomes easy for me to navigate the material and also easy for you to follow what we are putting out as a general introduction to the field of interpretation. So usually when I get a chance to teach my course on interpretation of statutes, I begin with some of these ideas, which I'm about to present to you over the next 40 to 50 minutes. And then, of course, if people have questions or interventions, I'm sure there'll be some time for discussion. So let me just share the screen, and I just want to confirm whether everybody will be able to see the screen, right? So I hope the screen is visible. Right, excellent. So let me just begin with this narrative so that everyone can follow what I'm saying. And of course, from time to time, I will stop, try and explain the examples a little more. And if people have specific questions, I'm more than happy to take the questions either in the chat box or with Mr. Vikas's intervention. We can even have people speaking and putting forward their questions. So I think the first question that often comes up when people engage with the field of jurisprudence is that why should we even pay attention to the field of philosophy of law? For students, it serves as a foundation for much of the coursework that they're required to do, whether at the LLB level or at the LLM level. And especially even now, when we look at the coursework in other disciplines, such as sociology, history, anthropology, or political science, even those students now actually benefit from engaging with legal philosophy to some extent. As practicing lawyers or as people who are trying to study the law, it equips us with the conceptual tools which are needed for engaging in legal reasoning and providing a holistic analysis of official legal sources that we come across, such as legislation, judgments, and administrative rules. I'm, of course, using these words a bit generally because there are, of course, many other sources of law that practicing lawyers use on a day-to-day basis. There are many different forms of delegated legislation which people deal with routinely in civil courts and in high courts. But at the moment, I'm just beginning with the general idea that we do need a certain conceptual apparatus with us, even if we are engaging with the law at different stages in our career. So most significantly, I think the field of jurisprudence helps us because it helps us to become comfortable with the notion of arriving at multiple answers sometimes to a given social or legal problem and evaluating them from different points of view. And you realize the value of this ability only when you engage with people who are heavily invested in their own disciplines. Because I think as lawyers, we take it for granted that we should be able to look at the same problem, both from the perspective of, let's say, the petitioner in a rights-based case or the government's position in a rights-based case. Even in a civil suit, even when you draft a plaint, you not only try and come up with the strongest arguments that you can on the basis of the laid down facts or the available law, but you also try to anticipate what the other side might say in their written statement. So obviously, this ability to engage in arguments both constructively and negatively is a central part of a lawyer's skills. And I would argue that that legal theory or a systematic study of legal theory at any stage of our career, right, can definitely help us in refining these skills. So it's useful to just begin right with the foundations by reflecting on what the concept of law means to each one of us. If it is broadly a tool of social control, how is the law distinct from other systems of social control, such as organized religion, market institutions, or government structures? Because eventually we can't deny that these are also institutions which affect our lives collectively and individually. Does our understanding of law depend on cultural particularities, or is there a universal conception of law? You might feel I'm starting in a very abstract way, but if you pick up any textbook on jurisprudence, or for that matter, any serious discussion on how legal norms sometimes move from one part of the world to another, very often you face this question that should the content of the law reflect the local customs and the sensibilities of the various religious or ethnic groups which are found in that part of the country or that part of the world? Or does the law have a universal character in the sense that the same normative standards and principles can sometimes be used to shape legal sources irrespective of where you are in the world? So it's an open-ended question. I don't think we can answer that question conclusively in an online session, but it's just food for thought for those of us who have joined, those of you who have joined us this evening. Then, of course, there are questions which have been seriously discussed in our older cases in constitutional law. What are the basic features of a modern legal system? In the context of the amending power of Parliament, we have a long line of cases beginning from Kameshwar Prasad Singh versus State of Bihar to the Keshav Nanda Bharti case in 1973, which looked at this question even more systematically in terms of whether the courts had the authority to review the validity of constitutional amendments that were being brought from time to time, especially to preserve the validity of land reform laws. So most of you, of course, would be familiar with that older debate in constitutional law, but there is a clear connection between a central issue in jurisprudence about how do we locate the basic features of a modern legal system and the way in which we study the history of the litigation involving the right to property of ancestral landowners and the various state level laws which were enacted to identify the surplus land, to distribute the surplus land amongst landless laborers and small farmers, and the litigation that happened over questions of compensation and the fairness of the proceedings. So we don't need to get into those examples, but I'm sure all of you can see the connection between the general question of how we locate the central features of a legal system and the specific debate which happens in Indian constitutional law, especially in the 1950s and 60s, over whether or not courts can protect the basic structure of the constitution. Then, like any first-year student of law would tell you, how do we acknowledge sources of law? What are the acknowledged sources of law? Itself is a very tricky question which we have to grapple with as we enter the domain of legal studies, either at an early stage and sometimes even at later stages in our careers, when we encounter some uncertainty or disagreement about what should count as law in the first place. And these questions come up routinely in the context of personal law and customary law, but you also have the field of international law, where the idea of traditional legal sources such as legislation, precedent, and judicial decisions itself comes into question, because there are newer forms of laying down norms, newer kinds of documents which come up from time to time, and legal theory has to keep up with such developments. So in a general sense, the field of legal philosophy, or jurisprudence as we call it, generally asks two branches of questions. And even today, even in 2020, when we divide our courses at the undergraduate level, and in some cases at the LLM level, we generally have two separate papers for jurisprudence. I think that is the practice in most law schools, though of course there might be variations from state to state and from university to university. So generally the first course on jurisprudence is framed as an introduction to legal philosophy. And I think the central question that we often try to answer in an introductory course on jurisprudence is, what is the nature of law? Is it derived from a determinable set of authoritative sources, or is there an inherent fluidity or flexibility in what serves as the basis of law? This might sound like a very obvious and innocuous question, but when we start locating it in trying to understand the various legal systems in the world, we get different answers depending on the cultural context or the national jurisdiction that we are talking about. Since we often say that India is part of the common law system and has deep connections to the Anglophone world in terms of how we situate the sources of law, we often say that apart from the idea of Parliament being the primary source of law in terms of making legislation, we also have an important role for the judiciary, which by virtue of its powers of interpreting the Constitution also plays the role of laying down what the authoritative meaning of the Constitution should be. So in that sense, we have some answers to this question in the Indian context. But if you look at this issue from a philosophical lens, there might be several additional questions that you might want to ask. Ultimately, if we are giving a place of primacy to judicial power, and we see it as a mechanism to check excesses by the executive or excesses by the legislature, how do we arrive at a theory which explains this issue to a larger section of the population, right? Especially the challenge, I think, for those of us who are studying, analyzing the Constitution today is not so much to speak to each other and engage in, let's say, arcane debates about doctrine, which only interest us. I think the owner of legal knowledge, right, to expand the understanding of these concepts and take them to a much larger audience. And I think for that purpose, it is also important to ground our understanding of constitutional law and legislative developments in some understanding of legal theory. I don't think we can separate theory from practice and say that I'm only interested in the practical dimension. And a few
Mr. Chauhan, your full face is not coming on the screen.
Dimension.
Mr. Chauhan?
Okay, I'll just modify. Yeah. Fine. I think, is that better now?
No, yeah.
Right, okay. So it might just be my posture is bad, right? So, so we have a tendency to believe that, we must only specialize in our practical areas and engage in discussion and debates with fellow practitioners who know that area of law very well. There is definitely a value to that, because ultimately a lawyer's services are also like an entrepreneur. You try to convince people that you have the skills to persuade the bench to give the relief that your clients want. But I think theory and practice have to go together, especially if you have to explain the foundations of our legal system to a much larger audience, and to do it in a persuasive way so that people also start believing in the ideals of the Constitution. The second approach, which is what I'll try and outline today, and this is how I introduce the course generally to our students, so I'll just try and do it in a more compact way, since we have a more mature audience here. Secondly, when we have courses on jurisprudence, we focus on interpretation, and where we focus on what methods should be adopted to interpret and apply the presumptive sources of law when disputes arise as to their meaning. So if legislation, administrative orders, and judicial decisions are amongst the various sources of law that we routinely deal with, and we can add customary sources in areas like family law or religious law, and in some cases we can even add international legal materials depending on the citation of treaties or agreements which might be relevant to a certain issue. So irrespective of the kind of sources that you may encounter, there will always be problems related to their interpretation. So the answers to these questions have evolved distinctively in different legal traditions. Apart from formal processes of legal change, such as the enactment of legislation, the framing of administrative rules and orders, and the pronouncement of judicial decisions, there are also several other factors that contribute to the same, such as customs, institutional structures, and scholarship. So in the course of my discussion today, I'll try and outline what are some of the larger approaches towards the question of how to examine nature of law, which I will do a little quickly. And then in the second part, which I think we'll spend a bit more time on, we'll talk about the larger debate around the interpretation of ambiguous legal language, right? Language which is capable of being interpreted in more than one way, because that was the decided focus of our talk today. So to quickly go through some of the ideas which I'm sure many of you know from your previous studies, we can refer to the following clusters of ideas to understand the various approaches to the study of legal philosophy. Broadly, there are three clusters, so I'll just quickly outline them because I'm sure this is an informed and mature audience, and most of you already know this. There is the natural law tradition, which I'm describing as the first cluster of ideas that we study in analytical jurisprudence. Then there is legal positivism, which is what most of us are accustomed to. And the third one is legal realism. So let me just quickly outline these ideas, and then we'll move on to the discussion on interpretation. So when we talk about the natural law tradition, of course, there is a rich literature on the connection between religious beliefs and how some aspects of religious beliefs often get codified into law. In some cases, you have religious beliefs that get carried forward into customs, especially customs pertaining to family relations, to property inheritance, and in some cultures, even mercantile transactions. But in India, one can argue that the role of religious beliefs has been limited largely now to the domain of family law, because that was also the path taken by the colonial state, which interfered more in public law, more when it came to taxation, criminal law, and to some extent, constitutional law. But areas like family law and inheritance were left alone and were largely left to the religious beliefs of the communities. So this approach emphasizes pre-existing higher sources of law, such as religious beliefs, or in some cases, humanist moral values, which ultimately shape the content of customs, legislations, administrative rules, orders, and so on. So in other words, this approach has two distinctive strands. There is the older theological religious approach, which also has been rejected in many countries. In many countries, you have a strong shift towards secular beliefs and secular values. So laws which have a religious foundation or the content of rules which are linked to older customary religious beliefs have been gradually removed. But in a complex country like India, where we have forces of tradition and modernity contesting with each other all the time, one would argue that there are some branches of law where the influence of organized religion and religious belief is still very strong. On the other hand, when we study political theory, we find that much of the argument for human rights, much of the argument for recognizing newer rights into the text of existing rights rests not so much on looking at religious beliefs. Very often, religious beliefs are inconsistent with newer arguments for recognizing human rights. The newer arguments for human rights often looks at the individual as an end in themselves and prioritizes the goals of individual liberty in a certain society. So I know I'm summarizing a very complex idea in a simple way, but this is just background information which we can just quickly look at. Before we concentrate on the larger trend, on the larger debates around interpretation. In the humanist approach, the ideas of justice, ideas of liberty, ideas of equality, or ideas of fraternity, all of these are ultimately humanist and secular ideas that need to be constantly interpreted for each generation, right? These ideas are not static, which means the fact that the Constitution was enacted in 1950 does not mean that our understanding of these values is linked to what was discussed or what was debated in the Constituent Assembly. These ideas have to be understood in a dynamic way in terms of newer social, economic, and political problems that arise from time to time. So this is, of course, one way of looking at the field of jurisprudence, but obviously not the only way of looking at the field of jurisprudence. The mainframe approach that most of us get used to is called legal positivism, or what we may also describe as formalism. So this approach, which stresses upon the black letter tradition in legal analysis and interpretation, forms the core of what we normally study at our undergraduate and postgraduate phase, right? So this entails the treatment of law as an autonomous discipline, that the law is separate from other areas of knowledge creation, it's different from other professions, and it has its own internal logic for identifying, classifying, and interpreting the different sources of law. So this approach describes official sources of law as part of what we might describe as a self-validating system that ultimately relies upon ideas of political authority. In other words, the authority of law is presumed because the state is legitimate, right? So in legal positivism, we are not looking at an external source like religious beliefs or external sources like abstract notions of human dignity or human liberty. We are looking at the content of the laws as they have been laid down, perhaps in the case of our constitution, the constitution which has been enforced, and under which you have other sources of law, such as ordinary lawmaking made by parliament or state legislatures, decisions made by administrative branch officials, and decisions coming from courts from time to time. So this is what we call a self-validating system, because the existence of these institutions itself is something that we see as legitimate and necessary to have a civilized government. And the argument of legitimacy is grounded within the idea of the modern nation state, right? We don't look at any other idea to try and justify the authority of law. So again, this is a question that has been explored with a lot of depth by legal philosophers, but at the moment, I think we just need to understand this at a skeletal level so that we can see the connections between the central approaches to the field of jurisprudence and the more narrower debate about interpretation. So legal positivism pursues the objectives of seeking clarity and predictability in the eyes of the participants in a legal system. Participants can, of course, include practitioners and judges, but also includes litigants and the large general public at large. However, the academic work in this area can be differentiated into two separate strands. One strand is what we might call exclusive legal positivism, which this approach that insists on a strong separation between social moral judgments and legal analysis. The most well-known author who you associate with this approach is John Austin, who wrote a book called The Province of Jurisprudence Determined, which I'm sure many of you would have read in your early stages of study. And he was seen as a proponent of a view, while he was also trying to say that the natural law tradition had its problems. So his argument that laws have a self-contained nature and that the authority of the law flows from the authority of the state was in a way a response to older arguments which used to privilege religious beliefs as a source of law. And he pointed out specifically the problems that had arisen in medieval England, especially when the church used to be dominant upon the state, because religious beliefs would invariably privilege the preferences of the majority religion. It would necessarily give more power to religious priests and institutions rather than secular institutions and common law courts, which were competing with them for power in medieval England. So this idea that the natural law tradition has outlived its utility and we require a state-centric positivist notion of law comes largely from the scholarship of John Austin. However, the current literature in the field is not normally identified with this idea of exclusive legal positivism. We follow the approach of inclusive legal positivism, which requires legal analysis and interpretation to be seen as a distinctive field of knowledge. It has its own unique characteristics, but it also acknowledges that from time to time, we have to draw on insights from other academic and practical disciplines as well. So in particular, when we start thinking about jurisprudence, inclusive legal positivists will argue that we cannot ignore the knowledge and insight into human institutions which we gain from other fields such as sociology, economics, political philosophy, and intellectual history, to name a few. Of course, that range can keep expanding depending on the area of law that you are interested in. So H.L.A. Hart who is amongst perhaps the most well-known legal philosophers of the 20th century, wrote a book called The Concept of Law, where he explained this idea in painstaking detail. And he is credited with framing this approach called inclusive legal positivism and setting the agenda for modern studies in jurisprudence. So he takes a stand on many foundational questions. I will only look at one of his questions in the second half of my talk, where he talks about the approach towards reading ambiguous language and the methods to interpret it. Now, of course, if you are a serious student of jurisprudence, you would have already seen that H.L.A. Hart's ideas did not go uncontested. Much of what he published in his famous 1961 book was contested by another legal philosopher called Don Fuller, who was based in the US. He published a book called The Morality of Law in 1964, which was offering some very sharp rebuttals against what H.L.A. Hart had written. And of course, there is a later work called Law's Empire by Ronald Dworkin, which is now considered to be the central book in the field, because he offers a slightly more newer and constructive way of looking at the foundational questions in jurisprudence, and he improves upon while disagreeing with both of these earlier authors who had come earlier. So if you have studied jurisprudence systematically, you would have definitely come across the names of these three authors. But rather than talking about all of their ideas, I will just locate one example or one question on which the three of them have different things to say, which is what approach should we take when we encounter legal language or provisions that can be read in more than one way with equally convincing reasons and justification. So that's the point that I want to gradually come to. So to quickly run through the other idea, the third cluster which I had, which I think is also important, but many of us struggle to engage with this approach. Even I know people who have a lot of experience, even with teaching or research, or even for that matter, adjudication, who don't really feel comfortable with this approach. But we do have colleagues from other fields who are constantly pushing us to think in this direction. And this is the cluster called legal realism. So this approach entails the study of jurisprudence in an interdisciplinary manner. The basic insight is that legal analysis and interpretation does not have an internally coherent structure. So they disagree with the legal positivists, and they argue that more importance should be given to the actual social consequences of the operation of laws. One way to understand the realist approach in simple words is to go back to the distinction between what is called the law in the books and the law in action, which were phrases used by a famous American law professor called Roscoe Pound. Roscoe Pound, in fact, originally was Canadian, but then later served in the US as the dean of the Harvard Law School. And he's credited with creating what is called the sociological movement of law, which is to bring insights from theoretical sociology into the understanding and interpretation of rules. So this simple distinction between what the law says, what does the language of the statute say, what does the order of administrative officials say, what does the language of a judgment say, as opposed to what is actually happening in practice, is an idea that he highlighted. And he said that increasingly we have to focus more on the law in action and not so much on the law in books. And his ideas, which were published in the early 20th century, in fact, have been prophetic, because now lawyers find it very easy to locate the formal legal sources. We have online databases, we have elaborate libraries. The cost of indexing legal documents has become much lesser. So more and more people have access to formal legal sources, but very often we don't have the tools or the patience to understand how that law is actually operating in the field, right? So this criticism applies not just to legislators who frame laws sometimes without thinking about the long-term consequences of their actions, but it also sometimes applies to practitioners who might be doing their best to get the best possible relief for their client and making the best possible arguments before the bench, but they may not be able to anticipate what the result of that decision will be in 5 or 10 years from now, or for that matter, even a generation from now, right? So that's a larger problem in organizing human affairs, that we cannot accurately predict what is going to happen even tomorrow. Forget about predicting what might happen in a generation from now. So in this view, disputes about the meaning of rules cannot be addressed without understanding the background and motivations of the individuals as well as the institutions who are connected with the creation, interpretation, and enforcement of rules, which means apart from studying the content of the law, we must also study the people who are involved in making the law. So if I was studying, let's say, the district court practice in a district like Ambala, which happens to be my ancestral district, it's not enough for me just to study the rent suits or the property disputes, which are the major chunk of litigation there, but I must also look at the motivations and the behavior of the local bar in terms of how they refer cases to each other, who has a more successful practice, how do the bar elections shape the local dynamics, and so on. So this movement towards law and sociology is actually taking the discipline in some very exciting directions. And if some of you are interested, I'm very happy to share notes on some recent scholarship that is coming, which is studying both the behavior of the bar, the behavior of the bench, and in some cases, even the behavior of litigants in certain classes of disputes. So there's a fascinating amount of scholarship that is coming, but unfortunately, most of that scholarship is coming from other departments. It's coming from sociologists and anthropologists and not so much from legal scholars. So as opposed to the legal positivists, the realists' approach firmly situates the study of law in the larger realm of the humanities and social sciences. Contemporary legal scholarship has extended the central ideas of legal realism to highlight problems which arise when legitimate interests are excluded while creating law. And we are seeing a great example of that playing out in the agitation on the borders of Delhi. So when we talk about the problems of legitimate interests being excluded from the creation of the lawmaking process, both at a formal level or a substantive level, then the critical legal studies approach comes in to point out why those gaps arose in the first place and what can be done to correct them, right? So the early movement in this approach was towards a sociological approach to legal studies, most famously developed by Roscoe Pound in the early 20th century. But over the last 100 years, we now have many subfields within legal realism, which are creating exciting possibilities for new scholarship. Apart from the sociological movement in law, which I think to some extent has been developed by leading legal scholars in India, such as Professor Upendra Bakshi, the other approaches have not, unfortunately, been as developed as they should be. Right? We are still looking to Western scholars and work from other countries to apply these tools, even in our own context. So there is the economic analysis of law, which is most famously promoted by the University of Chicago, where they examine laws not just through the lens of whether or not the enforcement of rules will benefit certain stakeholders or whether it will save costs for the economy, but even the behavior of institutions is assessed through economic parameters. So this approach is slightly different from what we might call the formalist approach to legal interpretation, because it requires knowledge of statistical methods and appreciation of economic evidence to be able to assess the impact of rules and decisions in the long run. It's a very fascinating field, but there are very few universities in the world which have created the intellectual capital that is necessary for this. The University of Chicago in the US is one such place where some of the topmost scholars in this field are operating. And in Germany, there is the University of Hamburg, which has structured research programs looking at the economic analysis of law. In India, we have very few institutions. I remember there is the Indira Gandhi Institute for Development Research outside Bombay, which has some scholars interested in this field. But many of the law schools are still struggling to incubate scholarship in this area. Then, of course, you have the Marxist critique of legal positivism, where you use the insights of legal leftism or criticism of the political economy based on the ideas of Karl Marx, and then you extend them to the assumptions behind modern legal thinking. So this approach, of course, is not very popular these days, but it used to be a very popular, especially in the 70s and 80s, when Indian legal scholars were also engaging with Soviet Union scholars, and those ideas were finding their way into the examination and analysis of laws. The feminist approach to jurisprudence, thankfully, has actually gained a fillip, who are trying to question not just the impact of laws, whether it is family law or criminal law, in terms of their discriminatory impact on women, but they're also talking about the assumptions behind lawmaking, which often reflects the man's point of view. So it's not just a question of uncovering the discriminatory impact of laws, but it's also saying that there is a problem of gendering or a problem of a gender bias which creeps in, even when we approach legal problems with the best of intentions. So the argument is more about structural biases against women rather than the absence of women in the literal sense. So again, this is a very exciting area, and we have quite a few people in the Indian context who have done great work on it, right? The critical legal studies approach, which I mentioned, has more to do with the perspective of marginalized groups or communities which feel that they were not adequately considered, their views were not adequately considered in the making of law. And primarily, this criticism extends to legislations which are sometimes passed in a top-down fashion without really consulting the affected groups as to the pros and cons of that particular subject matter. So this issue, of course, can be discussed with many examples, but I think we can leave it there because getting into specific point in time. So this was the portion which I thought I'll do a bit quickly because this is just a general background to how we approach the discipline of jurisprudence. Now I will slow down a little bit. What are the conceptual approaches that have been developed in the field of jurisprudence to study ambiguous legal language? So this is, if you have an interest in this material, we can do personal follow-ups or discussions at our own time later on. So when we read or interpret a statute, one primary question that we should ask is there a difference between ascertaining legislative intent and determining the legislative purpose of a provision? Textbook writers such as Aaron Barak have said that ascertaining the legislative intent, which is the intent of the lawmakers at the time that they were debating the law, or the intent of the drafters when a bill was being drafted, is actually a subjective approach, because the objectives that were in the minds of the people who drafted a law or who were discussing the bill in Parliament might be very different from the current context in which a particular law is being interpreted or enforced. And this is especially true for statutes which were enacted a long time ago. And the Indian legal system, as you're all aware, has many statutes which were created in the colonial period, but still continue to form the mainframe of our modern understanding of law. So be it the IPC, be it the Evidence Act, be it the Contract Act, be it the Transfer of Property Act, or for that matter, even the Code on Civil Procedure, are all statutes created by the colonial state. But because lawyers got accustomed to working these statutes on a day-to-day basis, and a large body of subordinate legislation also emerged under these statutes, we chose to continue with these statutes in the post-independence period, right? It was an argument of path dependency. Because we had chosen a certain path of respecting the authority of the courts in matters of interpreting legal sources, we also chose to continue with many of the important procedural and substantive laws which had been created during the colonial state. These days, of course, there is a committee, criminal law reform, sitting at NLU Delhi, which is going to be looking at the possibility of restructuring the IPC, the Evidence Act, and the Code of Criminal Procedure. And I guess those of you who are interested in criminal law would be very eagerly waiting to see what their report has to say. So some very good people are involved in that discussion. And the argument is that the Indian Penal Code is part of the colonial baggage that we have inherited. It might be time to reconstruct and restructure the criminal law of our present context. So we have to wait and see what that committee submits to the Union Home Ministry. And we might, in fact, see legislative changes very soon in the future. But ordinarily, when we read a statute, I think it's important. And if students end up seeing this content later, I must clarify that please use these expressions very carefully, because very often we conflate what is meant by legislative intent and legislative purpose. Please remember, these are two different expressions, because when you are inquiring into the legislative intent behind a provision that you are preparing a brief for, or you're briefing your senior on, that is a subjective approach, because you're trying to ask what exactly was in the minds of the framers of the law, or what was the original intention behind the enactment of that law. That inquiry is very different from determining the legislative purpose, which might be the immediate reason why you're studying a law, because either you have to make a submission in court, you have to prepare either an appeals memorandum or a writ petition, where you have to say that, look, this is the overarching purpose of the statute, which should be followed and implemented. And sometimes you might have helpful precedents which help you to determine what the legislative purpose is, but it's also possible that certain statutes have not been litigated extensively, and you may not be able to find any references in the law reporters which may help you to determine the legislative purpose. So scholars distinguish between what is called the subjective interpretation, where we are ascertaining the intent of the framer or the creator of the law, and determining the legislative purpose that should be given to the law in a holistic and objective manner. So remember, these are two different lines of inquiry. And as legal scholars, we have to be comfortable in engaging with both of what I wanted to say in the remaining 20-25 minutes or so. What are the conceptual difficulties in pursuing either of these lines of inquiry? One conceptual difficulty is of an epistemic nature, right? The word epistemic is a condensed version of the idea of epistemology, which means what are the methods that we use to create knowledge, to pass on knowledge, how to disseminate knowledge. And epistemic force us to ask which sources should we consult when we are trying to interpret certain statutes. And amongst a multitude of sources that may be available to us on the same issue, assume you have multiple precedents, some of them are inconsistent. You have statutes which are sometimes overlapping with each other in terms of their meaning and scope. So amongst a multitude of sources, which ones are more authoritative and which ones can be disregarded forms one of the foundational problems in legal research, right? Now, of course, there are some maxims that you can find in the common law system that help you to resolve some of these problems. For instance, one old Latin maxim is generalia specialibus non, which means that the scope of a general law can be derogated by a special law that might be enacted with a particular subject matter in mind. Similarly, there are older maxims of interpretation which help you to prioritize newer legislation vis-a-vis older legislation, especially when they're overlapping. So I don't have to discuss that because you can pick up any textbook like Maxwell on interpretation of statutes or Justice G.P. Singh's fantastic commentary on interpretation of statutes, which I still think is amongst the best books produced by an Indian judge. And they, of course, give you a systematic discussion of how these Latin maxims have sometimes evolved over centuries. In some cases have come from the British legal system into the Indian legal system. But Justice G.P. Singh's book also very beautifully documents how Indian courts have creatively used these maxims in many cases. But the current position that is taken in legal philosophy is often that many of these maxims may not be useful in the present day context, and we must approach this question of which sources are authoritative and which sources can be disregarded in a fresh way. So this is, of course, one set of obstacles which a young law student or a young advocate may face when they especially come across precedents or materials that are contradictory to each other or inconsistent with each other. A second level of problems arises when you're interpreting statutory provisions. How do we equate the intent of the primary movers or drafters of a bill with that of the legislature as a whole? Now, political scientists spend a considerable amount of time in pointing out the fallacies in making such an equation, but as lawyers, we often make this assumption all the time. So how do we account, for example, for disagreements which are expressed by opposition parties on the floor of the House? Should we consider the independent views expressed by civil society organizations, social movements, and other groups who are affected by the subject matter of the concerned legislation? And you can think about the controversies around the farm legislations and the recently enacted labor laws in relation to this issue. And how do we account for differences sometimes which arise within a ruling party, which has tabled the bill and sought its eventual passage? I mean, at the moment, we have a single party majority, so the differences within the party are not publicly expressed. But when you have a coalition government with multiple parties, sometimes they're pushing and pulling in different directions, and they might actually disagree on the viability of a particular legislation that is promised. So if these legislations do eventually get enacted, they get subjected to judicial interpretation, and you as a lawyer or a student are trying to make sense of that legislation several years later. How much information should you look at? Is it enough for you to just read the statute and say, I'm only concerned about the text of the language, and I'm only concerned about determining the legislative purpose as it applies to the interests of my clients, which is the objective approach that I talk about? Or should you take a scholar's approach, which is more subjective, where you examine not just the intent of the people behind the framing of the law, but also the difficulties and disagreements which they had to work through in getting that law passed? So just think about the way in which we study the Constituent Assembly debates and some of the best books which are available to us about the Constituent Assembly debates, right? So Granville Austin's book, which looks at the framing of the Indian Constitution, was published in 1966, but it was based on archives of the Constituent Assembly debates, which were maintained by Dr. Rajendra Prasad's office. And of course, he conducted a large number of interviews with people who were participating in the Constituent Assembly, be it K.M. Munshi or other surviving members of the Constituent Assembly who gave him time. So the question is that as a practicing lawyer, what happened inside the Constituent Assembly in terms of the disagreements or debates about the framing of this article might have limited value, because ultimately you have to press your point in front of a bench and say, reference helps me in my case, right? So a practitioner would have a very result-oriented view. But scholars or historians might look at the issue very differently, and they might in fact be more interested in exploring these older disagreements which might have gone on record, and where you can find documentary sources to say that even though the bill was enacted, let's say with a large vote, it doesn't mean that the bill was enacted unopposed. So this is the question which scholars of political science are more seriously interested in, because it's not enough to assume that all statutes were backed by unanimous votes. In many cases, you see legislations which were enacted through considerable disagreement and considerable obstacles, and sometimes simple majorities can be very narrow in terms of the passing of legislation. So the question is whether or not the nature of the passage of the bill should have an impact on the way in which that bill is interpreted in the future. So, and there is some exciting scholarship that is happening on these questions these days. Then, of course, there might be considerations that are particular to the lawmaking process of a certain country. So what was the nature of the procedures used for the legislative proceedings? The lawyer needs to know those proceedings. Was there scope for thorough scrutiny of a bill? Was the bill referred to standing committees for closer consideration? How was the passage of the bill shaped by the strength of a ruling formation making that require modified voting requirements to ensure their passage? So we know, for example, that amendments to the Constitution in India under Article 368 require bills to be passed by 2/3 majority in both houses of parliament. There are some categories dealing with the scope of executive powers, the question of legislative competence in the 7th schedule, and the jurisdiction of the higher courts, where amendments also require advance ratification by the state legislatures. Similarly, money bills are designated under Article 110 and are only presented before the Lok Sabha. So you have modifications in the way in which legislative procedures are designed. Some of them are there in the Constitution itself. Others require attention to be paid to how a bill was actually debated and discussed. And that legislative history should also be part of a lawyer's toolkit when you are willing to present arguments before a court, or you're trying to describe that issue to a larger audience. Now, in reading statutory provisions or other sources of law, be it judicial observations or administrative materials, we routinely encounter the following problems. And let me then come to the main part of what I had to say. How should we view the trade-off between the use of precisely drafted rules and general standards? There are many statutes that deliberately include general or vague language owing to the human fallibility of limited foresight. In other words, it is not possible for even the best of us to predict what might happen in the future. Hence, the drafting of statutes, the writing of judgments, and the issuing of administrative orders inevitably include some expressions whose meaning can be contested in the future. We can't always draft our documents in such a way, whether they are submissions in court or whether they are administrative rules, in a way that all of them will be precise and will not be subjected to argumentation or litigation, right? In spite of our best efforts, you may find that the language that you come up with, even through a thorough act of discussion and deliberation, can still be opened up for debate by later generations or creative lawyers who may litigate questions under that statute. So be it the Land Reforms Act in your state, to the Indian Penal Code, to even an ordinary administrative rule dealing with motor vehicles under the Motor Vehicles Act, you may find examples of ambiguity and generalized language in all such legal materials, right? It's something that a lawyer has to live with. In fact, I might argue that a lawyer earns their bread in dealing with these ambiguities and explaining to the court which interpretation should be chosen in a particular case. So when we encounter examples of vagueness in the law, how should we approach the same? And I'm just going through a process which H.L.A. Hart had suggested in his work. And then I'll just quickly outline how Fuller and Dworkin outlined disagreements with the approach which H.L.A. Hart had outlined. So H.L.A. Hart, in his famous book, The Concept of Law, and in an earlier article called Positivism and the Separation of Law and Morals, had suggested a two-step inquiry. Firstly, to examine whether the example of vague language in front of you should be considered as an example of ambiguity. That is, the text is capable of being read in more than one way with convincing reasons, or is it an example of indeterminacy, that it is improbable that the text can be given a tangible or practically enforceable interpretation. Now, in most cases, on a day-to-day basis, we come across examples of ambiguity. So whether it is penal statutes, whether it is tax statutes, whether it is rules dealing with property registration, or for that matter, rules dealing with vehicle registration, what we normally come across are words which are ambiguous. So H.L.A. Hart further suggests that we should further break down the possibility of ambiguities into two more subcategories. And I would request you to follow the logical link, otherwise it may not be clear, that if you identify ambiguities in the legal language in front of you, that can be broken down into two more subcategories. One subcategory is pervasive vagueness, where a provision can be assigned a fresh meaning on a case-to-case basis, which means the provision itself was drafted in such a manner that future interpreters can give it a fresh meaning depending on the facts in front of them. On the other hand, you have what is called the phenomenon of open texture in the law. So it is this last term, the idea of open texture in the law, which has occupied a lot of attention in the literature on legal interpretation. The problem of open texture arises where a rule was initially laid down with a clear and specific purpose in mind. However, with the passage of time and changes in the underlying social, economic, or political context, the meaning of the said rule becomes uncertain or ambiguous. So much so that subsequent interpreters, such as judges or administrative officials, can see a distinction between the core of the settled meaning that can be identified in the language of the rule and the penumbra of debatable possibilities that can be attributed to the same language. So the core penumbra distinction can be compared to the distinction between concentric circles. A core might be a smaller circle which captures the uncontested meaning of a particular provision, but the entire debate in a case or the entire debate in a piece of in an argument might be about the penumbral possibilities which may arise in reading the same language. So legal philosophers have spent a lot of time and energy in exploring this distinction between the core and penumbra of the varying meanings that can be assigned to a seemingly clear rule. H.L.A. Hart himself uses a famous hypothetical called "no vehicles in the park" to illustrate this conceptual distinction. If I may quickly indulge you on this example, though I'm sure many of you already know it, in his hypothetical, he assumes there is a residential colony with a park in the middle. The residents of that colony put up a sign called "no vehicles in the park" because they don't want people to be trespassing into their park and damaging the park, right? Obviously, you don't want motor vehicles to enter the park because that can damage the grass, it can cause public nuisance, and the residents of a colony may want to use the park only for recreation so that children can play, older people can take a walk, and there is no public nuisance caused by the entry of vehicles from time to time. Now, that might be the original intention of a rule like this, which a particular residential colony might make. But what happens when unforeseen situations arise? For instance, if a garbage truck comes periodically to remove the waste and then enters the park, would you prevent the garbage truck from entering the park? Because it is a vehicle and it is a motor vehicle. Now, any rational person will say, but that is absurd because you need the garbage truck to come from time to time to clean the waste which might accumulate, and hence this rule should have an exception, and garbage trucks should not be prohibited from entering the park. But what happens when a person who is accustomed to little interpretation starts interpreting the word vehicles in a very expansive way? What happens when a very aggressive resident who is very particular about maintaining the park starts saying that no one can bring skateboards, children's scooters, bicycles, or even baby prams into the park because all of them have wheels? Now, most of us will say that is an absurd interpretation because the original goal behind the rule was to prevent motor vehicles from entering the park, and it is completely absurd to prevent baby prams and bicycles and children's skateboards from being used, because that is the whole objective of the park. The children should be able to play without worry of interference. So this is just an example to show that even though the rule might have been made in a very obvious way with a very clear and tangible objective in mind, the actual interpretation and enforcement of that rule could still be debated and contested later on in light of new situations that might arise. So this is just a famous hypothetical which many legal philosophers use to illustrate the problems of ambiguity in the law, and in that sense are able to develop a more elaborate theory of how we must look at ambiguous legal language in different kinds of statutes. Now, the other scholar whose name I will mention is Lon Fuller, who disagrees with H.L.A. Hart on some of his arguments about the nature of a legal system, but I don't think we have the time to get into that argument today. But at the level of interpretation, Lon Fuller, who was teaching at Harvard, disagreed with this approach offered by H.L.A. Hart of exploring the open texture in legal language. Instead, he argued that interpreters, especially judges and administrative officials, must bear in mind that the overarching purpose of a given rule while deciding hard cases, which means cases which throw up difficult interpretive questions, most commonly due to conflicting policy objectives or inconsistent precedents. Those cases need to be decided not by looking at the open texture of law, but looking at the overarching purpose, the determinate objective purpose that can be assigned to that rule. Now, this overarching purpose should also be relatable to a morally justifiable objective that can be read into a law in cases involving apparent ambiguity. Lon Fuller further goes on to distinguish between the different layers of morality that may be read into a formal source of law. In his famous book, The Morality of Law, he describes these two different layers of morality as the inner morality of law and the external morality of law. Now, this is a slightly complicated discussion, so I'll just outline it quickly. When he talks, what he means by the inner morality of law is basic procedural standards which are necessary for the creation or enforcement of laws in a modern democratic country. So, for instance, laws should have general application, should not be limited to individual consequences and be whimsical. Laws should have a certain element of certainty and clarity so that people are able to follow them. Laws should be predictable. They should not be applied retrospectively. Laws should be enforceable. The population can't be asked to implement impossible demands made by the law. And there are basic norms of procedural fairness that are necessary for a legal system. So for want of time, I'm just mentioning a few of these ideas. But if you look at chapter 2 in The Morality of Law, which is a book published in 1964, Lon Fuller mentions at least 8 standards which he thinks are necessary to constitute what he calls the inner layer of morality that is necessary for the legal system to function. He distinguishes this inner layer of morality, which are mostly standards of procedural justice, with ideas of external morality of law, which, according to him, as well as H.L.A. Hart, should not be playing a dominant role in lawmaking. So this means laws which might reflect religious or socially sanctioned beliefs that prevail in a society should be looked at skeptically. And to preserve human liberty, you must sometimes be willing to disregard this external layer of morality that finds its way into the content of law. So this is another debate that happens between H.L.A. Hart and Lon Fuller on what is the proper role of moral judgments when it comes to the content of law. So H.L.A. Hart argues that law and moral judgment should be strictly separated because the authority of law comes from the elected parliament, the appointed judges, and the administrative branch officials who are tasked with making the law. And he insists that moral judgments have no necessary connection to the law because the law could also be made for other practical reasons, practical and secular reasons. On the other hand, Fuller takes a more nuanced view on this question and says that all kinds of moral judgments cannot be excluded from the legal sources. There is, in fact, a distinction between what he describes are ideas of inner morality of law and external morality of law, and argues that the inner morality of law would be necessary irrespective of the kind of regime that you're talking about. So this discussion happens more in the aftermath of the Second World War, where they were debating whether the Nazi legal system was in fact a valid legal system or not in the first place. So there were exchanges between H.L.A. Hart, a German legal philosopher called Gustav Radbruch, and also an important debate between H.L.A. Hart and Fuller, which is fleshed out in the literature, which I can only briefly mention here for the sake of reference. The third author, whose name I'll just mention and I'll conclude with that, is Ronald Dworkin, who in a series of articles and books, his most famous book is The Law's Empire in 1986, where he offers a general theory of law. But some of his earlier work, especially an article called The Model of Rules, published in 1967, and a collection of essays published in 1977 called A Matter of Principle, have built upon the ideas of Lon Fuller, where he has argued that decisions in hard cases, and by hard, we don't mean difficult cases because the factual matrix is very complex, or the case requires the study of multiple statutes or many legal sources. What is meant by hard cases is that interpreting the legal question there is difficult because there are multiple answers that are possible, and there are equally strong reasons or comparably strong reasons which one can offer to interpret the same rule in more than one way. That is what is meant by hard cases. Not difficult because of the nature of the material or the facts, but hard because there is a difficult interpretive question that is being framed in that case. So Dworkin, of course, argues that decisions in hard cases should not be constrained to the exploration of the penumbra of debatable cases, as H.L.A. Hart had suggested. Instead, they should be decided by identifying and applying the larger moral principles in a way similar to what Lon Fuller was saying, which offer the best account of a legal system's own history, the present circumstances, and the possible future. Dworkin argued that it was pointless to frame the approaches towards interpretation around the older binary in legal theory, which I began with, which was drawn between legal positivism and legal realism, right? Legal positivism is also often called formalism or conventionalism, and legal realism is also often called pragmatism or rule skepticism. So much of the older debates on interpretation had looked at positivism and realism as two opposite approaches towards interpretation, wherein positivism, you would focus more on following the precedent or following the textual language of a statute, whereas in pragmatism or realism, you would focus more on the need for doing justice to the parties who are before the court and not worry so much about consistency with precedents or adhering to the strict interpretation of the statute. So positivism and realism are often framed as a binary, as opposite forces in interpretation. Dworkin argues that it is wrong to assume that this binary will help us in deciding actual cases. He suggests an aspirational standard of searching for integrity in adjudication and lawmaking. This standard of integrity, which he fleshes out in his book Law's Empire, can be pursued by searching for deeper moral principles that may be embedded in older legal sources, though not followed at a popular level, and they can be read constructively to provide a better course of action for the future. So pursuing this approach of searching for the law as integrity would require both the elements of fit, which is looking backwards to see how to place the chosen interpretation within the larger moral principles which have been recognized in earlier cases, in earlier statutes, or in earlier constitutional provisions. And apart from the element of fit, which seeks to place your current interpretation with the older legal sources, you may also need to involve the element of justification, where you choose an interpretation that advances the cause of justice for the parties involved in a dispute. So again, I'm just outlining a few of the ideas which these three scholars have offered. Obviously, if we work through their books or if we work through their actual writings, one would have to make these arguments in a more elaborate way. But I've just simply tried to create an operative outline which will hopefully be of some use to students and young advocates who are interested in the field of legal theory. And there's no age limit for developing an interest in legal theory. You can always study it at any point in your career. So I have some examples which I thought I could have used as examples to illustrate what Ronald Dworkin tries to argue in his book. But I think I'll pause here and I'll share these notes with Mr. Vikas Chhatrath, who can definitely circulate it to other interested participants. But I think since I've been speaking now for an hour and I've largely followed the text, I think I can pause there and see if there are any questions or comments so that we can have a discussion if possible.
Yeah. In fact, I was just looking out here. There's no message, but on the YouTube, I was seeing a lot of people have written good evening to sir, and then one has taken Sujoy Pandav says very important subject and rarely discussed topic. Thank you for selecting such, and he's an excellent faculty. I will just check out on the Facebook.
Yeah. No, meanwhile, any of the participants who are here.
Yeah, that everybody knows that if anybody wants to post a question, he can do. No. So we don't have a question, but I can share with tomorrow's topic. And actually, as I had been recommended, that you speak excellent, and it was a rare topic to connect with that. It was a fascinating one. And friends, tomorrow join us on part 2 of our series of the Indian Succession Act. Tomorrow is Succession Certificate under the Indian Succession Act by Justice Rajiv Bhalla, a former judge of Punjab Haryana High Court, tomorrow at 5 p.m. So do stay connected with us. And Mr. Siddharth, it was quite engaging session. And as rightly put across on the YouTube, that it was a session which is a rare one. And as rightly said by you, even for the students as well as the professionals, it will be a topic. It will have a real purpose to be achieved if one actually follows it. And I will share this.
Yeah, I'll send the notes to you.
Yeah, notes you share with me, I will share it in the different groups. And thank you once again thank you to all the participants who have been watching us live on the Facebook, LinkedIn, and